feel free to see a copy of that afterwards as well too. And with that said, feel free to turn your camera on or off, whatever's more comfortable to you. Your microphone will be automatically muted. You will also be able to view this event better if you put your Zoom view to speaker view versus gallery view. You will see that on the screen as well. You will find that setting on the view icon. If you're using a laptop, you'll find that on the upper right corner of the Zoom screen. I believe if you have an iPad, you'll find that below. Again, we'll be monitoring the chat throughout today's event, so please post any questions or comments there. So let's get started. I'd like to introduce our guest presenter, Attorney Lydia Rincon from the Senior Law Project with Nevada Legal Services. Lydia?
Thank you. Good morning, everyone. Thank you, AARP, for inviting me. I am honored and looking forward to providing information to your members. So to get started, I just want to share a little bit about who we are, Nevada Legal Services. Next slide, please. We are the only nonprofit legal services law firm in the state, and we actually cover the entire state. We have offices in down south. We have an office in Las Vegas, so it covers Southern Nevada. Our offices up north, we have Reno, an office in Reno, Carson City, Yerington, Elko. And I am actually working out of the Reno office. We are federally funded through Legal Services Corporation. We also receive funds from Nevada Bar Foundation, the Attorney General's Office, and private donations. Next slide, please. Also, in addition to the Senior Law Project, we provide legal advice and counsel on different topics, on different areas of law. Our services are dependent on eligibility. Applicants can complete an intake and provide us with information about their legal issue, and then we determine whether or not we can provide services. Our priority is assisting individuals, constituents who cannot otherwise afford legal representation. And we do, like I said, it could be, our services can be limited to just advice and counsel on a particular issue. We also do full representation at administrative hearings, district court, justice court, and also tribal courts. And we do ask a lawyer events, educational seminars. Of course, pre-pandemic, those were live. Now we're limited to doing video. But I am proud that the Senior Law Project, we still do in-person visits at the senior centers, and I'll discuss that in a little bit, discuss it further. But for more information, you can visit our website, nevadalegalservices.org. We also have a YouTube channel, NLS Now Live, where we do different presentations. The hot topic right now, of course, are evictions. So we have several presentations covering that topic. Next. All right, so I sort of went over what we do, but we have different staff assisting with different issues. We handle evictions. That's the majority of our cases. We handle, provide assistance for individuals having to deal with consumer issues, bankruptcy, collections, termination of public benefits, unemployment denials also is a hot topic right now. We do criminal record sealing. We assist with eviction record sealing. And the Senior Law Project, which is my project, we handle estate planning. That's the bulk of what we do, but we can assist with other issues. And again, our representation is absolutely free, but it's subject to meeting our eligibility requirements. Next. And like I said, I am working out of the Reno office. These are the different areas and projects we have up north. Core Services, Tenants' Rights Center, Indian Law Project, Farm Worker Law Project, We also have Rural Consumer Law Project, the Pro Bono Program, where we have volunteers from the community assisting with representing our citizens, our constituents in Nevada. And of course, we have the Senior Law Project. For our purposes, 16 over is a senior. We provide services for residents in Washoe County, as well as the rural counties in Northern Nevada. Next. All right, and this is what basically the Senior Law Project assists with, or the services we provide. Like I said, we do a weekly visit to the various counties, the senior centers. Go to Lyon County, Churchill County, Pershing County. There we have signups. The citizens can ask any general question about any general area of law. I try to provide advice and counsel if we cannot represent. And of course, state planning is the bulk of our services, our practice. We are limited when it comes to estate planning. We are limited to only preparing last will testaments. If anyone wants a trust, whether revocable or revocable, unfortunately, we wouldn't be able to assist, but we could also, I mean, if we can't prepare the document, we can provide any other legal advice or answer questions regarding estate planning. And that is what I decided to focus today on last will and testaments. Next slide, please. All right, so let's see. Can we go next? Oh, okay, no, sorry. There we go. That's the one I wanted. All right, so of course we have to get into the legal before we start. This is just a disclaimer that the information I'll be providing is going to be general information regarding the topic. It won't be answering any questions from pertaining to your particular case. The questions, we do invite questions, and of course we would like to have them framed in the form of a hypothetical if possible, or if you need any clarification regarding the law or anything about our services, feel free to answer. This presentation doesn't establish an attorney-client relationship. And again, please include your questions in the chat, and I'll be happy to get to them at the end of the presentation. All right, so next slide. So of course, before we delve into the meat of the presentation, I just want to provide you all with the Nevada Revised Statutes, which is the law that governs wills in Nevada, as well as in a succession, which applies when people die without a will. They die intestate. And also this is the chapter 111. It's a big chapter, and it deals with property as well as estates and property. So those statutes are there for your reference. You could always look them up if you want a little bit more information. Next. All right, so NRS 134, that is the NRS, the Nevada Revised Statutes, the law that covers intestate succession. What that means is that when a person dies without a will, they're said to have died intestate. So what happens to their estate? So Nevada is a community property state, meaning that if a person is married, anything accumulated during the marriage belongs to both spouses. And in a community property state, the right of survivorship will vest according to the joint tenancy laws. Regardless how property may be titled, if there's a married couple, one spouse passes, then by right of survivorship, the estate should go to the surviving spouse. So we turn to also other, Chapter 123.250 is also provides guidance as to how community property will vest when a spouse passes. So NRS 134 applies to any separate property, property that's not community property. So property that was brought into the marriage, either was inherited or just brought prior to marriage. So when a person dies without a will, and one needs to determine how the estate will be divided, then NRS 134 provides that guidance. Next slide, please. So in a way, you could say that the law has a built-in procedure or process or estate plan for people when they pass without having their will. So the sections 134.040 through 120, they carve out how the property, and this is a separate property, would be divided. It covers if there's a surviving spouse and in children, or no children. So it covers different scenarios, and that's where we turn to if a person dies intestate. So a lot of times I hear at the senior centers that my friend died without a will and we don't know what happened to the estate. So generally, if someone dies without a will, this is where you would turn to get a flow chart, if you will, of how to distribute the estate. Now, the advantage of having a will is that you can, by having a will allows an individual to change the distribution scheme that is set by statute. So that is the advantage. A lot of times people, if they're married, they want the spouse to inherit, but there are instances that, you know, they want separate property to go someone else, and that is where a will would come in. Next slide, please. All right, so chapter NRS 133 is the law in the state of Nevada that covers wills. It is the authority under which the a will is prepared. And to start off, maybe some of us have heard that you need a person making a will needs to be of sound mind, and they also need to know the extent of their bounty or their estate. So a person has to be 18 years or over. I think our audience makes that cut. But basically anyone 18 years and over can make a will, and the will is that instructions as to how you want your things disposed of or distributed when the inevitable happens. So sound mind usually is determined by the fact that a person can identify their heirs and what they own. And by identifying heirs doesn't mean the heirs are going to be beneficiaries automatically. We'll go into that a little bit later, but that is how you determine your soundness of mind. Next slide, please. Okay, so there are, I think it's 3 different types of wills that are legal, or types of formatted or formats that can be used in Nevada. Half of the states also in the country have similar formats. One that is commonly known as a handwritten will, it's called a holographic will under the legal term, I guess, under the statute. So a holographic will, as you can see here, these are 2 examples of the holographic will. Basically, it's a handwritten will. It's signed by the person who is writing it. It's dated and it disposes of their property. Next slide. Whenever I bring up holographic wills because it's helpful in case you're in between having a will prepared and you need to have a document. A handwritten will would be valid under the state of Nevada as long as it follows the requirements under the statute. And again, the requirements for a holographic will is that the material provisions of the document be written by the hand of the testator, the person who is making the will. That document, a holographic will, oddly enough, does not have to be notarized. It doesn't have to be witnessed. It only has to be dated and signed and completed by the person making the will. I like to tell the story that how I learned about holographic wills, if we go back all the way to law school. This was done, if I remember the case we studied, it was a farmer. Farmer Brown was out, on his tractor in his farm. He started feeling sick. He felt he was having a heart attack. He wanted to leave a will behind, didn't have one, didn't have any paper. So somehow he would manage to write down how he wanted his estate to be disposed of on the tractor. So there was a piece of the tractor that contained that information, and that actually was determined that it was a valid will. And it was, a last minute thing, but he was able to write down what he wanted to do or have done with his estate. In the news, you'll probably hear about, I think Larry King also is another example of having left a holographic will. And yes, holographic wills may be challenged in court as to their validity, but that can happen to a typewritten will as well. Next slide. So ideally, you want, if you're going to have a last will and testament prepared, it's in your best interest to have a formal will, because again, although there is really nothing, when an attorney drafts a will, we try to draft it as best as we can, as tight as we can, that it's not challenged. However, there's really no safeguard against challenging will, but between a formal will and a holographic will, clearly it's advisable to have a typewritten will. However, if the circumstances are so that you need to have a will for some reason, holographic wills would be something to keep in mind. And then, it also can serve as a stopgap measure. If you are in between, again, wills, you can have the holographic will. All right, so chapter 133, again, is the wills. Next slide. And 133.040 is exactly, it provides the what makes the will valid, okay? These provisions or these requirements generally are applicable or the same in every state. I don't think I've come across a state where it might have different requirements, but I only practice in Nevada, so I know these are the requirements in Nevada. As long as a will, if you're residing in Nevada and your will's drafted according to the statute, a question I get a lot is, if I move, is that going to be valid? The will, regardless, if it was prepared in Nevada in this state and you move somewhere else, the will is still valid so long as it was prepared according to the statute. Of course, if one moves from a state and the estate changes, it's good to update the will, but it's not really necessary. So chapter 133.04 NRS, basically, a will, if it's going to be a formal will, is not written in hand, but it's typewritten. The person who writes the will or the testator who makes the will, they sign the document, and then two competent witnesses, meaning two adult witnesses who are disinterested, who are not heirs, they witness the execution of the document. So they're witnessing that the person who is signing the will is who they say they are, and it's their will, and it's their way. It's their will, and it's the way the will matches their desires or what they want, how they want their property disposed of. And a lot of questions, or a big question that I get when I visit the senior centers is, does the will have to be notarized? And that, like we saw in holographic wills, holographic wills do not need to be notarized, and formal wills do need to have a notary stamp, but it's important to understand that the legal requirement is not necessarily notarizing the will, but notarizing or attesting that the witnesses saw what they saw. So it's the witnesses really who are declaring that we saw Mary on this day sign the will, and it is their declaration and their signature that gets notarized. So yes, the requirement, a will to be valid under NRS 133 would be typewritten, signed by the testator, witnessed by two people, and then their declaration is the one that is notarized. There is an exception in the law that does not require the document to be notarized if the witnesses can affirm by way of another document, a declaration that they saw the signing. But as a practitioner, I rarely recommend that anyone, if you're going to have witnesses, I highly recommend that their signature be notarized. During the pandemic, we did resort to eliminate the notarizing of the signatures of the witnesses and just have the witnesses sign a declaration under penalty of perjury. This was something this office was doing in the beginning of the pandemic, but I highly recommend to just, if you're going to have witnesses, just have it notarized. Next slide. All right, so we talked about the type of wills that exist under the law or that are acceptable. Also the requirements to draft a will, which is over 18, of sound mind. You understand the bounty of your estate, meaning you know what you own and what you don't own, and you know who your heirs are. So what should be included in the will? And a lot of times, and also the majority of the citizens or senior citizens I just talked to at the senior centers, their interest also in having a will is because they want to avoid probate. Probate, sometimes we have a bad reaction to hearing that word, but according to the NRS, all states have to go through probate or through the probate process. But the advantage of having a will is that that process may be faster, or it also limits the court's involvement in the distribution of the estate. And that limit of, or limitation set on the court, it depends on a lot of factors. It depends on the size of one's estate, the value. Clearly, the higher the value of an estate, that would require more involvement by the court, because the court is there to oversee that the distribution of the estate happens according to the wishes of the decedent. There is some property considered to be non-probate property that can be transferred from a decedent's estate by operation of law or contract, and therefore is not needed to be included in the will. So while the will is your instructions as to what you want to do with your earthly possessions, if you have some items that are already titled or have a title or have a way to add a beneficiary, it's highly recommended to handle that outside of the will, because that eliminates the need for probate court to be involved with that distribution. For example, I've listed here some examples. Like I said earlier, community property or property held as a joint tenancy, and the other owner doesn't necessarily have to be a spouse, but if you hold real property in as a joint tenant with right of survivorship, it's kind of the distribution is built into that way of holding title. When one owner dies, the second owner will automatically receive that property, and it would just be a matter of transferring title. So probate court wouldn't have to be involved there. That item doesn't have to be included in the will. Of course, it's recommended that the testator do something about that property, and transferring it outside the will is the best method to do that. And I indicated there that the mechanism or the document that allows for that transfer is a document titled Deed Upon Death. The NRS 111.655 to 0.699 discusses that further, and actually there is a sample of what the document that needs to be recorded at the recorder's office. So property can be transferred that way because the law supersedes the will. So in this case, if joint tenancy, if that's the mechanism to transfer property to the co-owner, the will won't really, help in that case, because the transfer will happen automatically. Similarly with vehicles. Vehicles, they're considered to be personal property. Because they have a title attached, our recommendation is generally to just handle the transfer of the vehicle outside the will. So again, probate court, by doing this, and not only your estate will go down in value and will prevent, cut down on the hearings that might happen at probate court, but again, by operation of law, upon the happening of that event, which is the death of a person, of the owner, if during lifetime, a transfer on death application is submitted to DMV, along with the required payment fee, then the owner of the vehicle can add a beneficiary to the title now, and then upon the event, upon the death, then the car will simply be conveyed to the beneficiary, and they would be the new owner. So that eliminates the need to go to probate court to have the judge decide or who gets the car or how it's transferred. All this is handled with paperwork, and I cited the DMV's website for more information. Financial accounts, life insurance proceeds, same thing. It's highly recommended to add a beneficiary to your bank account if you don't have a bank account already. If you don't have a beneficiary attached to your bank account, you can do that by visiting your bank and asking to create a transfer death account. Again, what is the advantage of that is that upon death, the named beneficiary will be entitled to have access to those accounts. And again, doing this, adding beneficiaries to titles or bank accounts, that is part of the estate plan. So estate planning is not only I need to have a will, but you need to have all these items in order, because the whole goal here is to have something ready for whomever's going to be your executor. They know what they're going to do with their your estate, or you can simplify their task by setting all these beneficiaries during lifetime. And that way, you know, you show really your intent of who should get what. It cuts back also on questions. So if you really wanted Susie to get your bank account, you name Susie as beneficiary. And if it's not included in the will, it's okay, because if she's a beneficiary, the bank, under their regulations, are obligated to transfer the account to the beneficiary. So that is non-probate property. So next slide, please. So we do this, we try to separate the property that can be transferred without the need of a will by way of the non-probate transfer, by way of contract or operation of law. And then we have tangible personal property or monetary gifts that do not have a title, and those do need to be included in the will. However, under NRS 133.04, there are various ways to transfer personal property. And one way could be by way of a specific gift within the will. If you have an antique that you want to give a specific person, you could do a provision in the will that is specific to that antique. For example, you have a lamp, you want to give it to Bobby. You can specify in your will, you should describe the item as best as possible. I want the blue lamp to go to Bobby, and that's a specific gift. And upon death, when the executor is distributing the property, they are responsible for making sure that Bobby gets the blue lamp. The benefit of doing a gift or a conveyance by way of a specific gift is that it abates if the item is no longer in existence. So if the blue lamp broke after you did your will and you just didn't have time to update the will, the provision will say that Bobby gets the blue lamp. But you know, if the lamp doesn't exist, then your state is not obligated to compensate Bobby in any way. Now, the disadvantage of having a specific gift in the will is that if you change your mind about who should get the will or who should get the property, the blue lamp in this case, and you have a provision in the will saying that, then if you change your mind about who the heir should be, then you are required to update the will, and you would have to amend it and basically, you know, create a new document. So to eliminate that problem under Nevada law, tangible property can be distributed in addition to being given out specifically. It can be distributed by way of a written statement that is attached to the will and reference in the will. If you go to NRS 133.04, it gives you that explanation. So basically, you do your will. We're gonna pretend, you know, the only thing you own are tangible personal property. Your will be a general will, and we'll talk about residuary clauses in a second, but you have your will, but then you have all these personal items. So I get this question a lot too. What do you do with them? So if you want to, there are various ways to handle it. You could either distribute it now if you want, or if you want to wait to when you pass. The easiest way to give away those items would be by creating a list saying these are, you know, you identify what the property is, and then you identify who you want the recipient to be, and you sign that document, you date it, and you reference it in your will, and vice versa. And then that document actually is a valid way of conveying or transferring property upon your death. This list only applies to tangible personal property. You cannot identify monetary gifts. You cannot list real property there. So it's just a list of your personal belongings. Now, this list, the law allows for it to be modified anytime. If you change your mind about who should get the lamp, you can destroy that document and create a new document. You could put a line through the item and make sure you make it clear that you were changing that gift, that former gift is no longer valid and that your new gift is this. But that eliminates the requirement of having to redo the will every time you give away tangible property. Now, pets, let's not forget about our pets. Our pets, they are family. However, for estate planning purposes, pets are considered to be personal property. I mentioned pets because it has come up recently as to what does one do with your fur babies upon your death. So again, the law says that pets cannot inherit directly, but humans can leave gifts for their pets. You can leave your pet in care of someone and provide that person some a trust, a testamentary trust within the will that gives the pets an allowance, or you can give the pet outright and just give them a monetary gift. You could also state in your will other instructions as to what you would want the pet for your executor to do with your pet. The whole purpose of having an estate plan in place and a will is for that to arrange that your possessions are taken care of, are handled. You want to tie up all loose ends before the event happens. And, sometimes we don't think that our pets can be included in our estate plan, and they sure can. So that's something to consider. Now, the last point I have on this slide is, as the do not include list, is funeral instructions or last wishes. It's common to include it in the will. I don't know if that's been just tradition that it was included, but in my opinion, and I advise my clients, is to, if you do want to have it in the will, that is fine. However, the important thing here is to make your loved ones know what your wishes are, what your instructions are. So if it's okay to plan ahead and have that in order, if you don't want to plan, you want to make sure that someone does do what you want at your time of death. So I recommend not including that information in the will. However, it doesn't make the will invalid if you include it, but it makes more practical sense to advise your family, to let them know what it is that you want. All right, so next slide, please. So I kind of mentioned residuary clause. So don't forget about the leftovers. And I'm not talking about turkey leftovers. I already had several turkey sandwiches. But what I mean is that a residuary clause should be included in every will. And this serves as a catch-all provision for gifts that you forgot to give, or items you forgot to give away, or anything that you acquired in the future that you weren't able to add beneficiaries or include in your will. Having this clause in your will is really what will help the distribution, or at least avoid any confusion as to who should get what. This, if you've seen a will, if you're familiar with what a will looks like, this provision usually starts with these words: I hereby give, devise, and bequeath the remainder and residue of my estate. So that covers everything that is not already dealt with. So my recommendation is, client has property, real property. We handle the real property outside of the will with the deed upon death. And then the car the same way, and the personal property by way of the statement, the letter. And that gives us just have a will, some people call it simple will. I call it a residual will, or a will with a residuary clause. And it basically covers anything else that you might have forgotten about or omitted, or again, acquire in the future. You'll be covered with this clause. So this is if you forget to do anything, I mean, the best way to protect yourself is by having a residuary clause in your will. Next slide, please. So, final thoughts. Wills are revocable. I know people change their mind and about gifts, so they are revocable. There is a particular way to revoke the will. A will can be revoked by a new will, and as long as you declare in that new document that the new document revokes any prior wills. But also you can destroy the will. You can physically destroy it with the intent of revocation. Wills, again, can be changed. How the method in which the will is drafted is the same way the changes have to happen. So if you did a formal will, typewritten will, with the two witnesses, and it was notarized, your codicil or your changes, your amendment to the will has to be done the same way. So sometimes it's just easier, and I recommend, sometimes it just makes sense and it's easier just to create a new will instead of having to add anything or an amendment. If you do have a will, wills do become public information at the time of death, when the law states that, wills have to be presented to probate court 30 days after a person has passed. Then that document is lodged with probate court and it becomes a public document. So a lot of times people prefer not to have that information made public. So in the alternative, they create a trust. But unfortunately, for our purposes today, I won't be discussing trust because perhaps I forgot to disclaim the fact that Nevada Legal Services is only assist individuals with last will and testaments. We do not handle trust. But the most important thing about when you draft or have a will drafted is to remember that it is your estate. So you are making choices as to what to do with your property. You decide who gets it. But the best advice that I got was to pass along the information that it's best not to rule from beyond. In other words, it is your estate. You can do whatever you want, but it's highly recommended to not put any conditions on your gifts. And that could be a whole topic for another conversation. But if you are going to give a gift, it's best to just give the gift outright and not put conditions, because the reality is that you're not going to be around. And if the your goal during life was to make things easier on your heirs, then placing conditions on gifts is probably not the best way to achieve that goal. So those are my final thoughts. Again, a will is a component of your whole estate plan. So your plan, again, you can establish a plan by going to the bank, adding a beneficiary to your car title, life insurance, add a beneficiary, and then complement that with a will, and that would be your plan as to what will happen with your possessions at the time of death. Next slide, please. So that concludes really my prepared information I had for you all. We've reached that time in the presentation for questions and answers. I believe we've been including questions in the chat, and I appreciate that. So Justin, take it away.
Thank you, Lydia, for a wonderful presentation. Personally, I learned some great things today. So I want to thank you for some of the information that you brought forward, because it's going to help me immensely going forward. We will unmute everyone in just a moment. Just a reminder that this event is booked until 11:30 p.m. However, this will be based on your questions today. So if we have a few questions, we'll end the event a bit early today. So if you'd like to ask a question, you can do so live or via the chat function. But first, let's take some questions from the chat. Charlie, do we have any questions today?
Actually, it's been very quiet in the chat because Lydia has covered just about everything that I would have to ask. But the only question that came in the chat was about trusts, and Lydia explained that very well. We're sorry, Kathleen, but we'll have to work out trusts some other way. But I do have a question, if Lydia doesn't mind. Since Nevada community is a community property state, but say I have a will, but it's an old will, and I've acquired property and everything since that will, but then I pass away and I do not have a what do you call it? A residuary?
Yeah, residuary clause.
Yeah, residuary clause. How is that handled? How is that extra property that say might not be specifically stated in my original will?
Okay, so there is no clause, the residuary clause in there. In your case, I would, I would have to look at your document, because maybe there's no residual clause written in that manner, but there's some other language that covers any property acquired in the future. A good practitioner would include some language of that sort in your document. So if you're concerned as to what would happen with items acquired in the future not mentioned, it would be a matter of looking at the document. Of course, it's recommended that if someone does acquire property after the will's prepared, is to update that document. Of course, in the will, we always try to have a contingency plan in the event of something happens, but sometimes you are, life happens, you cannot get to updating. And that's where those clauses or that specific language would come into play.
Very good. Thank you very much. Also, yeah, there is, let's see here. I got thank yous coming in.
Charlie,
Thank
I
you,
do have
everyone.
one question that just came in privately. It's
Okay.
from one of our attendees. Would you recommend to list a third or fourth beneficiary, such as your children?
Are we talking in the will or as like a financial account, or if they weren't specific? Well, you can, I always tell clients, have a contingency heir, in a backup. So generally under Nevada law, it goes down the line. For example, if your son is your beneficiary in your will, your heir, and your son unfortunately predeceases you, but they have children, then under the law, they should be entitled to inherit your son's share, because it goes down the line by representation. Now, if that child is a minor, then it would be necessary to hold their inheritance or in trust for them by an adult. So if you have a will and that happens, there's really less ability to change that. But if you are adding beneficiaries to financial accounts or anything that you're going to deal with, the non-probate property I addressed, some of those requirements would have to address with for example, if it's a bank account, you would have to go to the institution and ask how many beneficiaries you can list, and is there an age requirement to list them? So I hope that answers the question if I understood it correctly. So, I mean, there's nothing against leaving property for minor children. It's just you have to somehow have someone in charge of that property until the children are able to own property.
Thank you, Lydia. I hope I answered that person's question. If not, you can always email us at arpnv@arp.org, and I can pass it to Lydia. Also, when we're done, I'll turn the next slide to her contact information. Actually, I'll leave that on the screen so everybody can have it just while we're asking questions, and I'll pass it back to Charlie to ask more questions that are coming through the chat.
Very good. Thank you, Justin. I've got a private one here that Nick sent me. He said, on his DMV website, is there a spatial location that you go to transfer of death application for vehicles? Or do you have to call them on the telephone?
No, the forms are readily available online. Actually, the form number that you're looking for is BP 230. Now I forgot. But if you go to the website, there should be a section that addresses estates and addresses. It'll say on the main screen, if you were looking at the Nevada website, it says transfer on death application. So you look for that wording. It gives you instructions as to how to complete the form. Basically, it's $20. You add a beneficiary, you submit your title. In return, DMV will send you a new title with the name of the owner and the name of a beneficiary. And then, you know, at the other end, when the person passes, the new owner would have to go deal with DMV. But the form, they're available there in instructions. Yeah, I could give a specific link maybe at a letter.
Well, I think that should be good enough because there's so many links up there. I know I've gotten lost on DMV questions, but I think you're right. If you do the search on transfer of or death application, transfer of death, that will come up. So I've got another one for you, Lydia. If a will is made in Nevada, and I move, say, to Canada, is it legal in Canada?
There is actually a provision in the NRS that discusses foreign wills. Generally, I mean, under the, which I can't remember the name, but generally, like I said, in the United States, if you prepare a will in state A, as long as it's prepared within the guidelines as following the law, it should be recognized in the other state. In a foreign country, some jurisdictions might require the will coming from another country to be domesticated. That's usually a process that is done either in court or maybe in the probate court over there. My recommendation is that if you do move to Canada or anywhere, then, you know, consult local counsel there. But I would, you know, I'm pretty sure it would be recognized, but it's best to consult with local counsel because there might be a minor step such as that domestication of the document.
Thank you, Lydia. Got another question here. If I have a mortgage and when I pass away, what is the best way to transfer to my children?
Okay, so the mortgage passes with the property, with the real property. So when, say that you do choose to do a deed upon death, add the beneficiaries to that deed, that handles the title part of the property. That's recorded with the county recorder. Upon your death, the mortgage company will find out that you have died, even though they're not notified. We know they find out, but once the mortgage company becomes aware, they determine, they'll look to see if there's a deed upon death recorded. And if there's new beneficiaries, the mortgage will reach out to the beneficiaries. And really, they don't have to assume the loan if they don't want to. If the beneficiaries don't want to pay the loan, they could give up the property. But the way is the best way, if I could get the question, I pass, okay. So the best way to add to the will, it would be, I would recommend doing a deed upon death. That way it's outside the will, and the heirs would be able to deal with the mortgage company once the property is conveyed.
Good, very good. Here's one that I didn't even think of, and it's a good one from Gary. It says, "Can an heir also be a witness on the will?"
No.
Okay.
Yeah, if we go back to the initial requirements, that's where all the red flags get raised. The witnesses should be two disinterested adults, and disinterested means they have no stake in the state, or they don't have an interest. Also, caretakers, that comes up a lot. Listing a caretaker as a beneficiary is also red flag zone, and a practitioner is, or a good practitioner would ask more questions as to why the caretaker is the heir. If the person is under duress, giving away their property to the caretaker. And again, I come across a lot of these scenarios at the senior center. Caretaker convinces the testator to leave them something in the will. So those type of gifts are the ones that are red flags and would raise problems in probate court.
Thank you,
But
Lydia.
yeah, to answer the question, no, it has to be disinterested.
Got it. Thank you. Here's a good one. And I think I'm going to ask this the way she wrote it, because it is a little confusing to me, but is designation of medical and financial people to handle things before your death part of your will?
Yeah, and I'm glad you found that question, because I did see it in the chat, and that's a very good question. I like to explain that a will doesn't go into effect until death. So it's really just a passive document that won't go have any legal authority until you die. So if you want to designate someone to handle your affairs, your financial affairs and health affairs before you die, that would be part of the advance directive, which is part of the estate plan, but it's sort of a separate topic in itself. But the documents that you would need to designate or give someone authority to act on your behalf, especially if you become incapacitated, is a power of attorney for financial decisions, or a power of attorney for healthcare decisions. Those documents are valid during lifetime, and they have validity even if the person becomes incapacitated. Their power or authority ends at death, and that's when the will comes into play. So yeah, that would be part of an estate plan, but it's a separate subject than a will.
Very good, very good. And of course, this is a good question. If you have beneficiaries on your bank account, but you also want expenses paid, what do you do?
Well, it's kind of like you have to think of when you want to give people authority. So beneficiaries are in the future. I like to use the term lying in wait, although, it's really, there won't spring into action. Nothing will happen because it's a future transfer. So bank accounts, There are several ways of doing it. If you want to limit someone's authority to just handling the payment of your expenses, you can add them as a joint account holder to your bank account. That way they have access to the money now. And, the checking account would be in both names, and both of you can, that person can write checks on your behalf. Of course, that's also when a power of attorney would be a good option. The power of attorney is generally it's very broad, but it can be limited to just that specific task. So there are different options. So a beneficiary is not someone who has authority now. The beneficiaries are in the future. So in this person's case, it could be if they want someone to have access to the account now, they would go to the bank and try to add an account holder to the account.
Very good. Very good. So we have a person that says she has inherited a partnership interest that owns real estate. How do I do a death transfer to keep it out of probate?
Okay, that's a very good question. Partnership.
Do we charge a fee for this, by the way, Lydia?
Well, today is Giving Tuesday. So
yeah,
we're
okay, Giving
for free.
Tuesday, good.
Although it's Giving Tuesday for me every day. This is a very good question. I think I might need a little bit more information if are they talking partnership as in like business partnership? So I'm not sure, but
yeah, Sherry, if you're out there and you want to ask that to the whole group and everything, please go ahead and unmute yourself and go ahead and speak up. If not, I think is that her?
Yeah, that's me. Sorry about the phone in the background. Let me
Happens to us all.
okay, dealt with that. Yeah, I have a partnership that owns real estate. And actually it's an LLC interest.
Okay.
And it owns real estate. What do I do with that to make it be non-probate property?
Okay.
So that it doesn't have to, and that I can designate who would I want it to go to.
Yeah, well, in your case, it sounds like a trust would be the best avenue, because
Okay.
I'll touch briefly on trust because it relates to this question. So a trust, people prefer trust because they do avoid probate. The issue with trust is that the owner has to transfer their title into a third entity that will hold that property. So basically the owner gets rid of their ownership rights and puts the property in this entity like the trust of Joe Brown. So by doing it, by transferring now, you're giving someone else ownership rights, and that's why probate won't be involved. So also in terms of your company, it might also be wise to do a trust because of the value of your partnership. Generally, probate court, if an estate is less than $25,000, probate is not involved, but the higher you go up in the value, they'll require hearings and transfers and accountability to the court. So in your case, I would advise that you consult with an attorney who handles trusts. And that would probably be the best avenue for you. Not a deed upon death, not a will, but maybe some kind of trust agreement. So one of the resources I didn't list, Charlie, was also the State Bar of Nevada has a legal resources, I believe it's called Lawyer Referral and Information Line, where individuals in the state can call and get a referral to 3 different attorneys in the particular area. And the attorneys on this list are agreed to provide a low cost appointment. So in this case, Sherry, if you don't know where to turn to an attorney, you could call the state bar and tell them, look, I need to talk, I need a name for 3 attorneys that I can consult with, and trust attorneys. So they would be best to answer your question.
Very good.
I hope that makes sense.
Sherry, thank you very much for that question. That was really good.
Mhm.
I've got actually, Gary has given me 3 questions here in a row privately. So I'm going to give them to you all at once, Lydia, and,
Okay.
and see how we go, because they kind of all relate. So
Okay.
the first one is, can or should you have more than one executor on your will? The other one is, can power of attorney be given to a family member that is an heir? And then, can a will be a video?
Okay. All right. So, okay. So first question, I always recommend contingency plans. So it's advisable not necessarily to have co-executors. That kind of gets touchy because they have to work together. So we don't know how the dynamics are going to be. But it is wise to have an alternate executor in case the first one doesn't want to do this. I mean, going through distributing someone's estate can become a burden on some people. So it is good to have an alternate listed in your will. In the event you don't have anyone that you trust or who you think will be up to the task, you could state in the will that the court appoints a guardian, a public guardian, to handle the estate, there to act as your executor. There's also businesses actually who are in the business of acting as executors, and who they can be designated with that task. So it is advisable to have an alternate. Because again, you don't know what would happen. Now, the power of attorney, if one wants to give authority to a family member who's an heir. Now, remember, we're talking about 2 different things. The power of attorney is allowing someone to act as your proxy and make decisions for you. Generally, people do designate family members to handle their business affairs because of trust issues. That document, there's a page in that document where it states that it's explicit, where that power of attorney is not giving people or your attorney, in fact, authority to make changes to your estate or your will or that type of planning. So the document, the fact that the family member might be acting as your power of attorney, that doesn't give them right to make any changes to your will or your estate plan. If they were to do that, that could be a violation of the authority granted by the power of attorney. So I've seen it where family members do have that authority, but again, their power is limited by the document itself. Now, can a will be a video? And there is electronic wills. I think due to our current conditions, people are moving in that direction to have electronic wills. It could be a video. It could be just done electronically without actually being in person. So that would be something, again, that we would have to look at the statute to see if that's allowed, and also perhaps consult with another practitioner who is more familiar with video wills. But I do understand that their wills can be electronic. Yeah, so I think those are all the 3 questions.
All right. Yeah. Excellent. Way to go, Lydia. That's why you're the lawyer and I'm not. So,
you.
yeah. Millicent has got a question here. She wants to know if property, car, and bank accounts are all transfer upon death. Does it need to be listed out in the will?
No, that is what we're trying to avoid by doing the transfers upon death. we avoid, if everything's squared away and you do what it's recommended, meaning you do the DMV paperwork, you have someone listed, then that it could guarantee that you don't have to, there's not going to be any issues in the future as ownership. So if you have that in place, we recommend that you not mention it in the will. And also that is when the residuary clause comes in. If for some reason you forget to actually go to DMV and complete the process, and you're thinking that Mary's going to get it as a beneficiary, but somehow the paperwork got not completed, your residuary clause would cover that car. If that happens, it would just have to be dealt with at probate court. So yes, if you handle everything outside the will, you don't need to mention it. If you have a residuary clause, that's your catch-all in case of any mistakes.
And hi, this is Millicent.
Hi.
Just a follow-on question for bank accounts. You had mentioned earlier that you can put someone as a co-owner or joint owner and also have them as beneficiary on death. Is that accurate? Or did I mishear, or how does that work?
Yeah, I don't recall if I said that. If I said that, maybe...
I just inferred.
Okay. Oh, okay. No, well, what happens is that a person who's a joint owner automatically becomes owner when the other owner dies. So they're kind of like a built-in beneficiary.
Okay.
So I don't think it would be necessary to list them as beneficiaries. Banks have their particular regulations. You could check with the bank, but I don't believe it's necessary for them to be joint owner and beneficiary.
Okay, thank you.
Okay.
So based on videos, Karen's got a question here. Can you video changes you want to make to a written will if you don't want to redo the will officially, or is it best to do the handwritten changes to the will?
Well, I think legislature has to catch up to technology. I think you're right now. I haven't come across anything in the statute, again, addressing videos, but the general requirement, if you're going to change a will, you have to make the changes the same way you did the will. Okay. So if I have a handwritten will, I do my changes handwritten. If I do a formal will, I have to do it with the formalities typewritten and whatnot. If that logic is correct, I mean, one can assume that if you have a written will, a holographic will, you probably won't be able to make changes by video. So that's my thinking. It would be a matter of revisiting the statute. And again, also, consulting with someone who is in that arena already doing video wills.
Okay, this is Karen. Can I ask, so did I misunderstand? I was thinking if you already have a official will done with the lawyers and you want to make changes, you could do the holographic will to make the changes, but you can't?
Right, you cannot. Yeah, maybe I wasn't real clear on that. Yeah, the holographic will, those are two separate documents. But yeah, the statute requires that any changes have to be done in accordance to how it was drafted. I might have mentioned the statement for the personal property. That's probably where the confusion might be too. If you have a written, typewritten will, a formal will, you can use that specific document for your tangible property and attach it to the will, and that can be handwritten. It's kind of confusing, but if you're using that document to give away personal property, that can be handwritten, that can be changed in your own handwriting. It's just the body of the will, then the separate document cannot be changed that way.
Okay, my other question
Mhm.
that I'm trying to figure out is when I did my estate planning, I did the directives for like financial, medical people to help me prior to my death if I need help, and
Mhm.
also the will. And
Right.
I've had to change it a bunch of times already. Right now, I just want to change the order of the people for financial and medical.
Mhm.
But I was told I have to redo the entire will, even though I'm not changing the will part, I'm just changing what happens prior to my death. I just want to change the order of the people. And
Okay.
so what do I need to do there? I can't just do something in writing and say, please attach this or please change this order. I have to redo the whole will, the whole advanced directives and all that.
Well, again, without looking at the language of your will, I mean, I don't know if there was a provision included that addressed the power of attorneys or the advanced directives. But assuming there isn't, and just how normally I handle these questions is that the will is separate and apart from the power of attorney documents, from the advanced directives. Both of them can be changed together, and both of them, you can make changes to the power of attorneys without touching your will. Because the power of attorney is a statutory form that's already, it's readily available. And you can just cancel the other one, the original one, if you want to change the order of the agents that you've named. But in my experience and my understanding, those are two separate documents. So one, unless you have a provision in the will that says that you must change the will.
I guess they did all three documents as one
Mhm.
one package, and when I called to find out about changing, they said I need to redo the entire package, everything.
Well, that is the common practice to do a estate plan. And again, you have to look, the estate plan is like the umbrella, and then it's made up of all these components. You have
Right,
the
right.
will, you have directive, but they're not connected. So I think in your situation, I'm not sure where you are in the state, but you might want to make an appointment with our office. See if you qualify for services, and we would be more than happy to review your estate plan. I don't know, yeah, without looking at it.
But you only qualify if you're low income.
That's one of the components, but not the necessary, that's not the reason why we wouldn't qualify. We have different grants and different requirements. Our senior law project is more flexible. So you don't have to necessarily be low income. We just look at other factors to determine eligibility. So I wouldn't deter you from applying for services, because we've assisted people who are not low income. We just have to make sure you're qualifying under the correct grant.
Okay, thank
Okay.
you.
You're welcome.
Excellent. We've got one here from Christina,
Mhm.
and it's, if I own my home, what do I need to do for my home to go into my 3 children's ownership upon my death? Can I avoid probate?
Right, yeah, so it goes back to the whole deed upon death document that can be prepared and recorded at the county recorder's office. And that basically is conveying your house to your heirs upon your death. So if this is important, and it's more applicable if it's only one owner. So if Christina owns the property solely, she can actually have that document drafted and saying that upon my death, I give my property to my 3 children. Whatever tenancy you want to give them, you record that, and that should avoid probate. If Christina owns the property with someone else, you could only give away what you own. But if you own it as joint tenant, the other tenant has a say in what to do. So there is a way to do it and avoid probate. You just have to look at how the title is held to complete the deed upon death.
Very
But
good.
that
Thank you,
is the
Lydia.
whole goal of that is the goal of having a deed upon death to avoid probate.
And here's one that I thought was obvious, but maybe not. Can a will have an addendum?
Yes, and that goes back to the addendums. They can be known as codicils also, but it's basically changes to your will. And again, is it addendum that they said? It would have to, like I've stated, whatever changes you want to make, the format has to match how the will is. So again, if it's a typewritten will, the extra document has to be done the same way. And there's a particular provision in the statute that outlines that. But in that case, I mean, I've had clients who want to add something, and it's again, sometimes easier to just draft a new will, especially if you've acquired property, other property that wasn't included in the original document. But to answer the question, yes.
Very good. Thank you.
Mhm.
And here's another one that they can be confusing, and maybe it is to me because I'm going to ask it because Rita's got a really good question here. I have a living trust. Do
Mhm.
I need a will also?
Okay, so a living trust is another name for a trust. So you need a will. That trust component or that document, it's basically has a will called a pour over will. And they work simultaneously. And that's all, it kind of works where a catch-all document to put everything in trust. So yes, those trusts do come with the pour over will, but they work simultaneously. That's the best answer I can provide, given that we don't really do trust, but it's not uncommon to have a trust and a pour over will.
Very good. Thank you very much, Lydia. In fact, okay. I thought that was the last question, but I've got a latecomer here, and it says that on my saving accounts, if I have beneficiary's name, does the bank contact them and does it avoid probate?
Okay, so it's like a two-part question.
Yeah.
I don't know what the guidelines are at the bank, if they notify that a person has passed, but if the beneficiary is aware, then they go and contact the bank and complete the paperwork that they need to do to get the account. I'm sorry, the second part was probate.
Yeah, does it
Yeah.
avoid probate?
That's the goal. Again, ideally, if you do it correctly, it avoids probate. And why does it avoid probate? Because again, the transfer from an owner to a beneficiary is considered an operation by of law. So the law says you can transfer these things, which includes the bank, without probate by doing this. So the law states that if you add the beneficiaries, then that becomes a non-probatable item. Of course, if there's a dispute, if someone comes out of the woodwork saying, hey, that was my account, that's where the problems arise at probate. But that is ideally what the purpose is of adding a beneficiary, to avoid probate.
Excellent. Well, that finishes out the questions, Lydia.
I
And
had
we
one
have.
more question there.
Oh, Karen, go ahead.
Yeah. I put it on there. Can wills be signed electronically instead of in person now that we live in the era of COVID?
Right, yes, and there is a provision in the statute about electronic wills. There are some practitioners already in the state who handle that way, who draft the wills electronically via electronic signature. So yes, you can do it. You would have to, again, consult with the state bar, maybe get a referral to attorneys who does wills that way.
Thank you.
Good. I did not see that one, Karen. Thank you very much for bringing
Yeah,
that up.
I'm just double checking the questions to see if we missed anything or if there's anything.
How do we get the
Okay.
recording?
What was that?
How do we get the recording of this?
Oh, that's a Charlie question.
Or that's going to be a Justin question. Actually,
Ah.
I think we have hit the bottom of the hour. And so I'm going to turn it back to Justin. Lydia, just to say, I have learned an awful lot from this, and I'm sure that our participants have too. I really enjoyed it. Thank you very much. Back
You're
to you,
welcome.
Justin.
Can, Justin, if I may,
Yes.
there is one last question I just wanted to.
Of course, go ahead.
To clarify, the question is, if both spouses die at the same time, are their children automatically the beneficiaries if there is no will? Okay, yeah, so if there's no will, the children would have to go to probate and open probate. And that is where I think in the first, one of the first slides where it says intestate succession, that will designate if the children who inherit. So in this particular scenario, if spouses die, yes, and the state, their separate and community property would go down to the beneficiaries because that's what the statute has already stated. And I think that was the last question. Yeah, I think so.
Lydia, I got to ditto what Mr. Charlie said. I want to thank you for a great presentation and also just taking the time to answer all the questions we had. Just a reminder to everybody that this event was recorded, so you will get a copy of this tomorrow morning. Be on the lookout for it. You may also want to check your spam box tomorrow morning. A few times it may enter there. So look out for that email tomorrow from AARP Nevada. It'll have a copy for your viewing pleasure, as well as more information about our upcoming events. For more info about Nevada Legal Services, please visit nevadalegalservices.org. You can also see their contact info on the screen. It has their phone numbers for their various offices, as well as other ways that you can contact them. I want to take the time to actually thank our state president, Charlie Shepard. For those who don't know, he's actually a volunteer. And, he did not have to offer his time today, but he did. And it's just a great reminder how important volunteering is. We'd probably have a very horrible RAND event if we didn't have Charlie helping us out.
Yeah.
And
Thank you, Charlie.
I say that because we can always use help on our volunteer team. And if you're interested in helping us, please just email us at arpnv@aarp.org. And finally, I want to, on behalf of AARP Nevada, as well as our wonderful community partner, Nevada Legal Services, I want to wish you a happy holiday and be well and safe. Any last thoughts, Lydia or Charlie?
No,
Just thank you very much, Justin. And thank you very much, especially Lydia. Thank you very much.
well, thank you. I appreciate the time and the opportunity to reach out to your members. And again, don't let eligibility requirements deter anyone from contacting us. If there's a will, there's a way. So I had to throw that in there. I've been waiting for that one. But everyone have a happy holiday, and always remember, it's never too early to plan. And if you just want something done, just at least do a holographic will.
Excellent.
Thank you so much, Lydia. Hope to do more events with you. Look forward to working with you more. And thank everybody for their time today. We really appreciate your time. And just in the future, if we have events like these events are free to non-members as well. So feel free to share it to any of your friends or family that you believe can really use this information. Happy holidays again, and wish you all a great and wonderful Tuesday. Take care, everybody.
Thank you.
Thank
Bye.
you. Bye-bye,
Bye.
everybody.
Bye.
Take care.